this video, we will be talking about secured transactions for our MEE Highly Tested Issues Guide. To get started, you have to be aware of how secured transactions is tested. In terms of frequency, it's tested about once a year, and additionally, it is usually tested on its own and not with another subject. But it has been combined with contracts and real property in the past. We recognize that secured transactions is a difficult subject for a lot of examinees. But while many people find this subject challenging, the good news is that it is somewhat predictable in terms of what is tested. Additionally, we find that if examinees have a decent hold on the basics, they tend to do well on a secured MEE question. And this is because even when the question tests a nuance or an exception, other parts of the question still touch upon the basics. Thus, examinees who can discuss the fundamental concepts on an essay score well, even if they do not get every possible point. We also find if you focus on the fundamentals and the highly tested topics, you can walk into the exam feeling confident. So let's turn to the highly tested topics. The first topic that I want to discuss is the application of Article 9. Article 9 is part of the Uniform Commercial Code and it applies to the following transactions. This is true even if someone does not know that they are entering into a secured transaction. It applies to all security interests in personal property or fixtures by contract, lease agreements that are not true leases, consignments, sales of payment intangibles, promissory notes, accounts receivable, chattel paper, and instructions, and health insurance receivables and commercial tort claims. Usually on the MEE, being able to tell the grader that Article 9 applies to the problem and why is the key. Usually it's a short and sweet kind of intro, and it doesn't have to take up a ton of time or analysis, but it is important because it lays that foundation for why you'll be talking about secured transactions in that essay. So let me give you a quick example in terms of Article 9 and its application. The law states that it applies to all security interests in personal property or fixtures by contract. So for example, if I buy a ring on credit from the jewelry store, and we agree that the store will retain title to that ring until I pay it off, then this is a secured transaction in which Article 9 applies to. The next highly tested issue I want to discuss is goods. Specifically, you want to be familiar with the different classification of goods. But before we dive into those, I want to point something out. A big mistake we see a lot of examinees make is that they focus on and get really caught up with the nuances of secured transactions without first focusing on what is highly tested or that big picture. So the classification of collateral is a really good example of this point. Here we're focusing on the highly tested issues of the classification of goods, and that's because it's, well, highly tested. We're not focusing on the classification of semi-intangibles or intangibles. And that doesn't mean you shouldn't study them, because you should, as a few of them have in fact been tested over the years. But since they are less frequently tested, if even tested at all, it's best to start with what is highly tested: goods. So let's define the different types of goods. Consumer goods are those goods bought primarily for personal, family, or household purposes. For example, if you bought a laptop to buy household items and pay bills and for your kids to watch Disney+, then that laptop is considered a consumer good. Inventory are goods other than farm products that are for sale or lease to be furnished under contract. For example, inventory includes things like at a store, or raw materials, or work in process, or materials used or consumed in a business. So to give you an example of this, let's turn to that laptop idea again. If a store is in the business of selling laptops and computers, then those laptops that are on their shelves available for customers to buy would be considered inventory. Farm products are goods such as crops, livestock, and supplies used or produced in a farming operation. This type of good has never been tested on the MEE. But to be thorough, an example of this would be seeds in the hands of a farmer waiting to be planted. And the last category is equipment. This is our catch-all, as it's defined as goods other than consumer goods inventory, or farm products. But the more common sense way to think of this category is things that businesses use to operate. So, going back to that laptop example, if you own a law firm and you buy all of your lawyers and support staff laptops so that they can do their job, then those laptops would be considered equipment. The next very highly tested issue is attachment. And before we dive into attachment, I want to remind you about the purpose of a secured transaction. A secured transaction makes the lender who's giving the debtor money secure. It's this idea that in the event the debtor doesn't pay back that loan or their debt to the lender, then that lender has an item that they can turn around and try to sell in an effort to make themselves whole. Now, if there's not attachment, then the lender is not a secured creditor and they can't do this. The only thing they can try to do is to collect that debt from the debtor like anyone else would, usually through a breach of contract claim. However, when you have a secured transaction, that means attachment has occurred. And this is when the lender has an interest in the collateral in question and is secured. On the exam, you want to spell out the steps for attachment to the grader. So the first step is that value must be given by the secured party to the debtor, and this is usually a loan. The next step is that debtor must have rights in the collateral that they're willing to put up for that transaction. So for instance, if I go to the bank to get a loan and they ask for collateral to secure it, I can offer them something that I own, not, for instance, something that belongs to my next door neighbor. And the final step to that attachment process is that the parties must enter into a binding security agreement. That leads us to our next point, the requirement of a binding security agreement. The mnemonic for this is AID, A-I-D. First, we need authentication by the debtor. This means the debtor signs that agreement. Next, we need intent to create a security agreement. The idea behind this requirement is that these agreements are voluntary. Lastly, the agreement has to have a description of the collateral. We should be able to read that agreement and have an idea about the item or the collateral that secured party has an interest in. The next topic that you should know well is perfection. Perfection is an issue when there are multiple creditors who have an interest in a single piece of collateral. So if you're familiar with real property, or maybe you like real property, you can liken perfection to the recording of a deed or mortgages. For instance, usually there is a real property question where multiple banks have mortgages on a single piece of property. And then usually the facts tell us that that buyer defaults. And usually the ultimate question is in which order do those banks get paid? Because all of the banks want their money, but usually there's not enough money to go around. So we have to know the correct order to pay the banks. It's the same idea here with secured transactions and perfection and priority. So usually the secured transactions fact pattern will tell you that there are multiple creditors who have all given money and they've all taken interest in the same piece of collateral. And then the debtor doesn't pay back their debts. So the question is, which creditor or secured party is going to get paid first? To answer this question, you need to understand perfection and priority. So first things first, you do not have to perfect a security interest. However, it is very smart to perfect your security interest because it essentially saves your spot in line in the event that debtor defaults. So there are 4 ways to perfect an interest. And the first is the filing of a financing statement. This document identifies the parties and that piece of collateral in question, and it's usually filed where your debtor is located. Next, there's automatic perfection. This applies to purchase money security interests in consumer goods. The next way to perfect is by possession. This means the debtor can literally take possession of that piece of collateral, and they remain perfected as long as they possess that item. Finally, there's perfection by control. This is common with collateral such as investment property, deposit accounts, and electronic chattel paper. The other principle in the Department of Perfection that they like to test over and over and over again is priority. This is important when multiple creditors have an interest in the same piece of collateral, and we have to determine who to pay first. You cannot discuss priority unless you first discussed perfection. Because remember, perfection is like holding your spot in line, whereas priority is the question about who is in line first. So, the general rule you want to memorize is that when two secured parties have an interest in the same collateral, the first to file or first to perfect has priority. If no party has perfected, then the first to attach is given priority. The third thing that we have for you regarding secured transactions is to make sure you have an understanding of the basics. As I mentioned before, trying to understand a nuance or an exception when you do not understand the basics is very challenging. Additionally, examinees can do well on the MEE when they have a good hold of the basics, even if they do not know every rule and every exception. This guide does an excellent job of outlining many of the basics for you, so be sure to check this out if you haven't already. Additionally, we've already talked about the majority of the basics in this video, so hopefully you find that helpful. Our fourth tip for you is to learn those basic introductions and vocabulary for each set of rules. While generally you want all of your essays to utilize the key vocab for each subject, it's especially true in the world of secured transactions. And this is because much of the words that you encounter here are unique to this subject. If you show the grader that you know those key terms and you know how to use them appropriately, they're going to have confidence in your answer, and it's going to be much higher scoring. There's a nice list of vocabulary that you should focus on in our guide, so again, be sure to check it out. Additionally, you can work on memorizing or practicing canned introductions to secured transactions issues. For example, you could come up with one for the classification of goods, or attachment, or a binding security agreement, perfection and priority. This way, you know exactly what to write down, and your only real job on exam day is going to be to analyze those issues. And our final tip is to practice. Many examinees spend a lot of time trying to memorize and understand the law as it relates to this subject, and they do not set aside enough time to practice. Practicing secured transaction MEEs is absolutely critical to your exam day performance. You will see how these issues are tested, and you're going to build confidence for walking into that exam. So that wraps up secured transactions as part of our MEE Highly Tested Issues Guide.